And these are the things we often look for. Insolvency or indebtedness of your debtor at the time an asset was transferred. If your debtor becomes insolvent at the time you made the transfer. If a debtor transfers all of his, her, its assets. Lack of consideration for the transfer or inadequate consideration in the transfer of property. A voluntary conveyance under either prohibited circumstances or suspicious circumstances. Oftentimes people will have loan agreements and loan indenture agreements in other matters where they're prohibited with negative covenants from doing things, and they go ahead and do them anyway. The pendency of litigation or the mere threat of litigation. I've sued you, or I'm coming after you, or other people have sued you or are coming after you. And in those circumstances, you start conveying assets. Certain insider relationships between the debtor and the people to whom he transfers assets, such as close family members and certain business associates. These can all taint a transaction. Or secrecy or concealment in the transfer of property, hidden conveyances that we don't disclose a public record, or departure from the transferor's usual course of business. The retention, and here's your Gulfstream jet plane example, the retention of possession, benefits, or use of property that you've allegedly conveyed away or transferred away. This is the classic I own nothing but control everything circumstance. The financial situation of the debtor at the time of the transfer or after the transfer. We look at that and get an overall sense of it. The existence of a cumulative effect of a series of transactions after the onset of the debtor's quote, quote, financial difficulties. We look at the general chronology of events that surround the debtor's business life, and his interaction with you. Also, facts or circumstances surrounding a transaction that indicate that your debtor is trying to hinder or delay or defraud someone, and especially a court or an opposing party or a creditor. We can get just as far with hindering and delaying as we can with proving fraud. So these badges of fraud that I've identified do not limit the range of what constitutes a fraudulent conveyance. But those are the circumstances for which we look, and when we show those, we're then entitled to reach the assets that we've identified through those mechanisms. Beyond that, I think I really need to know about your particular circumstances and what you can tell me about your particular debtor.